All right, we're going to get started. I want to thank you on behalf of the LRA for coming to Employment Law 101. This is something that we have done for the last few years. It's never been this well attended, but we are awfully happy to have you here today to share with you some information and some things that are of importance. As you know, first of all, I think you guys have met most of our LRA team that is here. Wendy Warren in the back, who coordinated this event for us, and Pam St. Pierre, who's our VP of Member Services, and the rest of our communications team. Steve Caruso, our COO, and I'm Stan Harris. I'm the CEO of the Restaurant Association. I call myself a recovering restaurateur. I got to spend 30 years in the business. I'm on my 12th step. I'm going to get a coin soon. But of late, when I got out of the business, I always said I wanted to have two things, no inventory and no employees. Well, I'm halfway there. But our industry of late has been under attack. There's no question about it. And it's been under attack for the way it engages with its employees. The media inquires regularly to us, what's the LRA doing? Thinking that we're some sort of regulator, not realizing that we're the advocate for the industry. And we always give the same comment. It says that we encourage all of our LRA members to be compliant with any law or regulation as it relates to employment discrimination or harassment. Now, that's never been in the media because that's just not the kind of meat that the media is looking for. Today, we put this gathering together to just share some information in three areas. First, we'll welcome our LRA employment law firm, Fisher Phillips, ably represented by two partners, Michelle Anderson and Steve Cupp. Both of them have presented with us before. And one thing that we will share with you as an aside that I know Michelle will cover, but in the event that you need an employee handbook drafted or something reviewed, they have a very good structured fee structure to be able to take care of that and assist you as an LRA member. So it's something that you certainly want to avail yourself of. They help us with ours, and I didn't know there was bone marrow leave in Louisiana for under 20 employees, so that kind of shocked me. We also welcome Postlethwaite Netterville. In addition to being a large CPA and tax firm, as they said, the needed CPA and the dreaded tax guy, they also provide HR and other consulting services, audits, consulting, and third-party resources. We're pleased to have Helene Wall, who's somewhere back here, that is going to present today, and she'll walk you through some ideas about what you should be looking for in your third-party provider or what you should be doing to protect your business. And finally, John O'Brien with Arthur J. Gallagher and Company. He's the Area Director of Hospitality and Program Insurance. John's one of my go-to guys when we need to talk about interesting risk situations, and he'll review specific insurance coverage and practices that you might want to consider. There'll be ample time for questions and answers, and as you note, we're shooting video of this, so if you'd like to share it with some of your colleagues that aren't able to attend today, it'll be on the LRA website at some point before too long. We do ask that if you're in the room, you silence your mobile device. If you need to step out and take a call or make a call, just step out of the room so we won't disrupt what's going on. And then just to share with you a little bit about how we look at the job that you give to us as the Restaurant Association and looking out for your interest and advocating on your behalf. We really do believe that restaurants are the fiber and part of the fabric of America. And whether you walk through the doors for a first date or a first job or a family meal or celebration, it all comes back into this experiential piece. You, as employers, provide fundamental skills and values that help people pave a positive path for their future. And it's our people, not just profits or assets, that are our most important element in what we do. And they're our greatest asset. But you know, we've got to get people that want to talk about personal responsibility, hard work, being disciplined, and having integrity. It's what our employees want and value, and it's certainly what you value, and it's what they deserve. So what we hope today that we help you provide a better understanding of your responsibilities as an employer and to have an engaged workforce in the hospitality workplace. So without further ado, we turn it over to Michelle and Steve and welcome you. Thank you.
Okay, well, we're so happy that you're here today. For those of you who I have not met before, I'm Michelle Anderson. I'm a partner with Fisher Phillips. I work here in our New Orleans office, but I also practice in our Tampa office as well. Some of you may have talked to me over the phone or even by email over the last several years. As you may know, part of your membership to the Restaurant Association gets you access to us. If you have some quick, simple questions, you're not sure how to do a tip credit, tip pool, you've got a question about overtime, you've got a difficult employee, we handle all kinds of questions from you guys all the time, and that's part of your membership, and we're happy to do that and really enjoy this relationship that we have. Again, Steve is with us, and he is from our Gulfport, Mississippi office, but also practices here in Louisiana. And he will be chiming in. We've sort of divided this, that I'm going to take the harassment discrimination side, and that he is going to talk more about the ADA, FMLA, pregnancy discrimination aspects, which will happen after the break. Because we have about 50 minutes and a lot to cover, normally the stuff that Steve and I are going to talk about is almost a full day of training. So I'm going to say lace up your shoelaces and hang on tight, because we're going to go quickly. There will be time for questions at the end, and this presentation will be made available to you, so don't feel like you need to sit there and jot a bunch of notes or take screenshots. I really just want you to listen and process the information, and if you have a question toward the end, then we will get to those. Just a little bit of background about me. I have not always been a lawyer, and actually probably don't like lawyers for many of the same reasons that you don't like lawyers. But my background was in workforce development, so I was on the management side, and I used to put people to work. I also am a former bartender, so I have worked in your industry as well. Several years ago, I decided that I wanted to go do employment law, and this is all I have done for over 10 years. So I bring to you my practical experience from the HR and the workforce development world, couple that with the legal experience of working with businesses solely to help try to get you in compliance and keep you out of hot water. Oftentimes I joke that if I work my way out of a litigation job, I'm okay with that, because that means that employers are taking the time and they're investing in themselves and their businesses and their employees to make sure that they don't become the next headline. And ironically, I have started to work my way out of a litigation job because people are calling me before they make that termination decision. They're calling me when they get that harassment claim, and we're working through an investigation to try and limit your risks. So, with all of that background, let's talk about trying to keep out of the employment discrimination and harassment news lines. So we're here to reinforce the zero tolerance. You should have a policy in place if you have, I would say if you have any employees at all, even if you are not technically covered by the law because you don't even have 15 employees yet, I think that it's still a good idea to have a policy in place. So we want to reinforce that message. Part of what today is about is I think we have to start reframing the culture of the hospitality industry. I recognize, having worked in it myself, many of us were very young when we started out. It was our very first job. A lot of us didn't know what it meant to be professional. And people who continue on in that industry over the years, a lot of times the things that we learn, whether they're good or bad, but sometimes bad habits continue to replicate themselves over time. And so we don't ever improve upon the culture of making sure that people are treating each other with respect, that we're doing things the right way, that we're being respectful. And over time, what has happened is the culture has become, I think, problematic, where a lot of things are going on that we know shouldn't be going on, but we don't know what to do to make it better. So hopefully today we will help you find ways to supervise and train and have a good, productive workforce to make sure that these issues of harassment and discrimination are not occurring in your workplace. Because quite frankly, if you have ever been through any kind of litigation, whether it's a harassment or discrimination claim, or even something, a workers' comp claim, you know how time-consuming and expensive those are. You know how stressful that is, and you know how much of a distraction it is from your business when you're trying to fight a lawsuit. So we want to try and keep that from happening. Of course, you should care because it's the right thing to do. Right? We don't want people to come to work. I always say this because plaintiffs' lawyers always say, oh, well, employers are so bad, and they hire these employees and they don't want to pay them right, and they want to treat them well and kick them out on the curb. I said, think about that statement. Does it really make sense that I'm going to spend all of my time trying to find the right person to make that job match, to bring them on, only to treat them poorly and to not pay them and then put them back on the street? Turnover is time-consuming and expensive, and the more turnover you have, the less business that is getting done. So the right thing to do is to obviously have a good, productive working environment. Of course, there's the numbers aspect. There's personal liability involved with many of these claims. Even if the company is considered the employer for purposes of a discrimination statute. There are all kinds of state laws that will allow an employee or even an applicant or a customer to sue you personally for some other kind of tort. It can result in people losing their jobs. It can result in people losing their businesses. The financial costs, particularly if you don't have an insurance policy to help cover some of those costs, can be exorbitant. And then, of course, I think we all know that unhappy employees are unproductive employees. At one point, I read a study that says it takes 21 positive comments to counteract 1 negative. So think about how much negative stuff we hear during the day on the news from our friends, our family, other sources, and think about how many do we really hear the 21 positive comments to counteract that 1 negative. So if you've got someone in your work environment who is harassing your employees, whether it's a customer, a manager, an owner, another employee, a vendor, are they really getting those 21 positive things to counteract that 1 negative each day? Probably not. Lots of laws. We could spend days talking about all of these laws. It would bore you to tears. But some of the ones that you need to be aware of that you're covered by are listed here on the screen. The main ones that we're going to be talking about today are the federal discrimination law, which is Title VII. We've got the Age Discrimination Law, the Americans with Disabilities Act, the Pregnancy Discrimination Act, and the Equal Pay Act. Those are the main ones that will be sort of in the background of our conversation today. Louisiana also has its own employment discrimination law as well. Covers many of the same classes, but has some different remedies to it and some different prerequisites before you bring a lawsuit. So who is covered by the discrimination laws? Everybody is. Applicants, employees, your managers, your vendors, your customers, your clients, everybody is covered. So even if the person doesn't work for you, if they are a third party and they come into your business and are harassing your employees, your staff, you could still be responsible for preventing a workplace that is free from harassment and discrimination. And I know, having worked in a bar myself years ago, it was not uncommon to get hit on by customers. It would happen, particularly the more that the drinks, and I could make a really good drink. And sometimes they just didn't realize that their inhibitions were going down, so my tip would go up. We know how it works. But it's, at time, as the employer, unfortunately, once we become aware that there is a situation, it is our duty to step in, to investigate, and remediate the conduct. So protected categories, again, these are a lot of categories, but a lot of what we're looking at today, of course, will be the sex and the gender, which has been one of the most prevalent issues that we're seeing in the news. But as I'll show you in a minute, actually not the most prevalent claims being made. Age, over 40, race, national origin, religion, disability, pregnancy, and then of course we have a slew of other federally and state protected categories as well.
Michelle, can I mention something?
You bet.
When I was going to school and going through taking classes in law school, we were always taught that sex discrimination meant a protection of females in the workplace. Race discrimination meant protection of minorities and African Americans in the workplace. That's not what it is these days. The law says that you're protected on the basis of race and sex, and that means both men, women, Caucasians, African Americans, and all ethnicities are protected in the workplace.
Right. Exactly. So the EEOC is the Federal Equal Opportunity Employment Commission. And some of you may be very familiar with the EEOC for a variety of reasons, but this is the federal agency that has been tasked with the enforcement efforts for several of those laws that I just mentioned: Title VII, age discrimination, disability discrimination, pregnancy, Equal Pay Act, and the Genetic Information Non-Disclosure Act. We don't see that a whole heck of a lot, so I'm not going to talk about that today. But they most recently released their statistics of charges filed for fiscal year 2017. So there were over 84,000 charges filed around the country. That is actually down about 6,500 charges from the previous year. Retaliation claims are now, for the 8th year in a row, the highest percentage of claims filed, nearly 42,000. And what retaliation means is I complained about something. I engaged in protected activity. I said I was being harassed. I said I was being discriminated against. And then you did something bad to me. You fired me, you demoted me, you docked my pay, you switched my shift, you did something bad to me. The reality is, and Steve and I both find this because we do EEOC charges and the litigation that comes afterward, oftentimes the person did not complain and they really don't understand what retaliation means. But we've also seen where the person has complained and the company didn't take it as seriously as they should have. And there were maybe some other performance issues going on with this person, because I have seen this, ooh, I've got written up for the third time, ooh, I was harassed. And so now we've got someone who is complaining now that they're in trouble, now they're trying to get someone in trouble. And the company doesn't want to take that seriously because they think that the employee is saying this just to kind of get a pound of flesh out of the company. The reality is that even if we think that's the case, it is still our duty as the employer to investigate that claim and determine if there's validity to it and to remediate the conduct. Now, that does not mean the person is bulletproof, that if they are breaking your rules and they're doing things they shouldn't be, that they can't be disciplined. But we just have to be very careful about how we handle those discussions. So,
yeah, and I do want to mention that you may look at the percentages and that adds up to more than 100%. Anybody who's seen an EEOC charge knows that you can check multiple boxes on it. So there may be a age, sex, disability, and a retaliation box marked. So,
I call them the kitchen sink cases.
Yeah.
I've had people, I had one several years ago, the gal checked every box, but she was like 19, and so age didn't apply, and she was white. Anyway, so you just never know. But Steve is right. You can check more than one box, and so we do typically see, you know, an underlying claim such as sex or gender discrimination, and then the retaliation checked as well. The EEOC does also file lawsuits, and I will tell you that I've litigated against the EEOC and won. And it costs my client a lot of money, because when you litigate against the EEOC, it's like litigating against somebody with a blank checkbook. So being sued by the EEOC is not a lot of fun. But last year they brought 184 lawsuits. Between all the various arms of the EEOC that does recovery, so that would be their litigation arm, their mediation arm, their conciliation, they have various processes, but they recovered $484 million for the claimants in the last fiscal year. That's a lot of money. So Steve kind of already touched on this, but unlawful discrimination is treating an employee or an applicant differently because of their protected category. So to piggyback on what Steve said, everybody's protected. You know, the way these laws started was it was to protect African Americans and other minorities. In fact, they threw women into the bill thinking that no one would want women to have equal rights, so we hope that it tanks the bill. Well, it didn't tank the bill, and the Civil Rights Act passed in 1964. And then you would hear these things such as reverse discrimination. Well, white men aren't covered. Everybody is covered. It doesn't matter what your race is, what your gender is. If we are making a decision about you because of those things, then we might have a problem with discrimination. So think about it broadly when you think about what could be discrimination. Variety of examples, it could be a difference in pay, where we are performing the same work, but we're not being paid equally when you look at apples to apples. Part of the problem with the equal pay movement has been we're not always comparing apples to apples, but there are some studies out there showing that when you do compare apples to apples, that there can be some disparities. Failure to hire. And this could be for a variety, on a variety of fronts. I'll give you an example. I had an individual was hard of hearing and was applying for a helicopter mechanic job. Well, guess what? Being able to hear is not an essential function of the job. But the person assumed that we didn't hire them because they were deaf. Well, there were 250 applicants for one job. We hired the most qualified person. But the individual filed an EEOC charge claiming that we failed to hire them because they were hard of hearing. Of course, the EEOC found in our favor that no, number one, we could prove that through all the applicants, we picked the most qualified one. And secondly, being able to hear was not an essential function of the job. And third, we actually had a helicopter mechanic who was deaf that already worked for us. But again, the problem is that applicants don't often know why we don't pick them, right? Because most employers don't tell them why they weren't hired. So if you have somebody who's out there thinking, well, all these employers keep rejecting me, it must be because of my race, or I showed up in a hijab, so it must be because of my religion, at some point, businesses start to draw these failure to hire claims. So you could get sued by an applicant. Failure to promote. I had a slew of these for a company several years back, where the progression within the company was not clear, how you could apply for internal openings to be promoted, or how you could get additional training so when those openings became available you would apply. And so the appearance was that a particular race and gender was getting the opportunity to get promoted and others weren't because they weren't in on the process. So again, those things need a level of transparency, because when they're ambiguous and you start looking from the outside in, it might appear that one class of people are getting passed over for another.
Keep in mind that any notes you take during the hiring process or promotional process may be discoverable in litigation.
Absolutely, and never write on their job applications. Never, never, never write on their job applications. Okay, more examples. Differences in job assignments, giving people better shifts or worse shifts, depending on which the case may be. You might be denying one person overtime and giving more to another, or more overburdening one group of people with overtime versus another, giving one group of people the dirty work and not the other, or the training opportunities. Differences in respect, how one group of employees are talked to versus how another group of employees are talked to, by differences of tone or respect, a different name calling, things of that nature that can be a problem. But the bottom line is if we are treating employees differently under similar circumstances, that's really going to start calling your judgment into question if it looks like we're treating one group of employees one way who fail to come to work repeatedly, and we give them umpteen chances before we write them up and fire them, and then we have another group of employees over here of a different protected class, and the first time they fail to show up to work or call in, we fire them. So we have to look at, when you have these disciplinary situations, have we had this situation before? Are the facts the same? Are these people in the same job? Are they doing the same kind of thing? How did we handle that situation before? If we're going to handle it differently this time, is there a reason we're going to handle it differently this time? I always say the facts make the law walk and talk. So sometimes we have some extra facts that maybe we didn't have before. But oftentimes we're going so fast, things are moving so quickly that we don't stop and pull back that institutional memory to think, what did we do before when this situation arose? And then all of a sudden we might find that, and it wasn't intentional. You're not intentionally taking one race or gender of people and treating them differently than another, but we might not really be looking at the whole picture about what we've done in the past, and it could be a hidden bias for all that we know. So you've got to think those things through. One
of the things that's important there is the different treatment based on a protected characteristic. And I think, Michelle, right, if you have a probationary guideline that says someone's on probation for 90 days of their employment, and they're frequently, and they miss 2 or 3 days in the first week or first 2 weeks, but you allow someone that's been with you for 5 or 6 years to have a little bit more leeway with discipline, that's not based on a protected characteristic. Right. Because one's a probationary employee and one's not. Now, it could look bad if all the ones that you are disciplining are African American and all the ones you're not disciplining are Caucasian. That could call into it. Right. But it has to be a protected characteristic. Right. And that's why I say you need to look at the situations when they're presented to you. When you have a disciplinary situation, you kind of need to look at the global perspective and say, what has happened before? How did we handle this? Did we treat someone differently? Would there be even the appearance that we're treating someone differently because of, because they're pregnant or because they have a disability? Why are we doing things differently this time? Obviously, termination is a very common claim that we see in discrimination cases. Sometimes because they'll say, oh, we're an at-will employment state, I don't have to tell people why I'm firing them. Technically, you don't have to, but the problem is when people are surprised that they're being terminated and you don't tell them why they're being terminated, guess where they're going to go? They're going to go to the EEOC, they're going to go to the Louisiana Workforce Commission, they're going to go to the Labor Board, the Department of Labor, and a plaintiff's lawyer. They're going to go find out why they were fired. So, and oftentimes what they'll say is, well, that's not the real reason. The real reason you fired me is because of my race. The real reason you fired me is because I'm pregnant or because I have a disability or I need to go on leave, not because I stole from you and then I quit coming to work. Again, sometimes we have to say, really, you wonder why you were fired? And sometimes they really just don't understand why they were fired. We recommend that you always be truthful to the person.
Yes.
Don't make up a false reason. If you have trouble getting the language together, call us and we'll help you. But it's much easier to defend the truth.
And the bigger, and one problem we see oftentimes is on the unemployment claim, because a lot of times employers don't want to fight the unemployment, and so they tell the employee one reason why they were fired, and they think they're helping them by filling out the unemployment paperwork differently so they won't lose their benefits. Let me tell you how many times that's backfired and called into question why an employer really fired the person when you've got an EEOC charge going on at the same time. So you're not doing yourself any favors by filling out one set of paperwork one way, telling an employee something else. If you really don't want to fight the unemployment claim, you don't give very much information, quite frankly.
Or don't even turn in it.
Because here you're supposed to turn it in within 72 hours, but quite frankly, they're not going to take away your birthday if you don't. So you can always wait for them to reach out to you to give the information, and then you can either not respond, or, for example, I had one recently where the person walked out, and there's a little bit more drama attenuated with it, but we could just say, quit, and not say anything else. That person will probably get denied the first time out for benefits. They'll appeal within 15 days. And what I tell employers is if you really don't want to challenge it, when they call for that phone hearing at 9 a.m. on a Thursday morning, you're out having a cup of coffee. Like, you're just not there to participate. Because at the end of the day, getting someone disqualified from unemployment benefits is very difficult, and it's usually not going to be worth your time. And there can be a lot of damaging things that come out in those unemployment appeal hearings because they are sworn under oath before an administrative law judge. And it's not uncommon for an employee to get a lawyer to jump on those calls and start questioning you under oath, and you don't have counsel. So you got to really think these things through when you're filling out your paperwork. Sorry, on a tangent, but these are these things that just come out as I'm thinking about them. All right, harassment. We've heard a lot about that lately. Who can be sued? The company, obviously. These statutes define employer as the company, but sometimes some of these statutes are actually broader and can also encompass the management and the supervisor. But there also can be individual tort liability under state laws for managers and supervisors. So we're talking assault, battery, intentional infliction of emotional distress, defamation.
Tortious interference with employment.
Tortious interference with employment. There's all kinds of things that you personally could be sued. Other employees could be sued. The owners could be sued. There's also a federal race-based statute where anybody could be sued, whereas Title VII would limit race discrimination claims under that to the company. There's a claim, it's called 42 USC 1981, and you could be sued as an individual for interfering with a racial minority's ability to contract as an individual. So I have seen business owners and managers sued under that statute as well in race discrimination cases. So harassment covers not just sex harassment, but sexual harassment and other kinds of unlawful harassment based on the protected categories that we looked at earlier. So sex harassment is a form of sex discrimination, and it's because of the person's gender. So because you're male, because you're female. So it can be same sex. Again, where these things originated from was it was meant to protect women, but the law evolves over time. And as I said, the facts make the law walk and talk. So over time, courts have looked at cases saying, oh, well, actually, that would fall within the umbrella of sex discrimination. So, for example, sexual orientation and gender identity are not covered under federal law. However, there are cases where they're called gender norming cases, where a female employee was not meeting the feminine standards of the employer's workplace, and she sued on the basis that she was being discriminated against because of sex. And they said, yes, if you are treating someone differently because they are not conforming to gender norms, then you are discriminating against somebody based on sex. So.
Yeah, and there are cases working themselves up to the circuit courts dealing with sexual orientation discrimination, and we predict probably not this term, probably the next term, the Supreme Court's going to decide that.
Yeah, they may take that on. But what has happened is many states have gone ahead and covered those protected categories anyway. And so, and some businesses have just said, you know what, a lot of people that work in our industry happen to be, you know, gay or lesbian, bisexual, transgendered, and we just really don't care, and we don't want that to be an issue in our workplace. So some businesses have just gone ahead and added that into their EEO classifications, even though by law they wouldn't have to, because at the end of the day, we want people to come to work and feel comfortable about being there and be productive and make us money, right? Because if they're not there, if they're there and being unproductive, or they're suing us all the time, well, we're not making money. So
I would recommend definitely include LGBT protections in your policy.
right.
That's
yeah.
the bottom line.
I do it all the time. I do 50 state handbooks all the time. I have clients that I update them twice a year, because if they're in California, the laws change like every time you blink your eyes. So, but a lot of them, again, have just done that because they're like, it's just something we really don't care to make an issue in the workplace. Let's just be all inclusive and recognize that this is the way it is, and let's focus on the positive aspects of the business. All right, sexual harassment, there's two different kinds. You've got the quid pro quo, or the this for that, and then you've got a hostile working environment. So quid pro quo is reserved typically to those who would have the ability to affect someone's terms and conditions of employment. So a manager, a business owner, a co-owner, supervisor, someone that could actually take action on that. So this is unwelcome sexual advances, requests for favors, basically saying if you sleep with me, I will hire you, I'll promote you, or I won't fire you, whatever the case may be. But basically the person who is propositioning that employee or that potential employee has the ability to make it happen. And so that would be the this for that. You do something for me, I will do something for you, or I will not do something for you.
And these are not that common anymore.
Well, they probably are not as common, but we see this come up in issues where managers are dating subordinates. And this is what I always say, look, I know we spend a lot of time at the workplace, and there are people who have met the love of their life at work. I have worked with married couples for years, and you wouldn't even know it because they're so professional. It does happen. However, most of us have exes for a reason, right? They are our exes and will remain our exes. And most relationships end, and most relationships end badly. And so before you decide you're going to date somebody in the workplace, you really need to think it through. And before you as a manager would do that, you probably want to say, no, I shouldn't, because the reality is you're going to probably try and keep that relationship a secret, right? Because you don't want everyone else to know. And as soon as someone gets their feelings hurt and there's a breakup, it's going to be, ooh, she made me sleep with her because she said I would get the best shifts if I did, or I would get more money, or I'd get promoted. You know how that's going to end. So don't date your subordinates, and don't let your managers date the subordinates. And I don't even like managers dating managers, but at least when that happens, at least we might be on some equal footing. But I also say if there's going to be a relationship in the workplace, it needs to be disclosed to, if you have an HR department, it should be disclosed, or if you don't have an HR department, then to the business owner, manager, because there needs to be a determination made about whether or not this is appropriate. And there might need to be a love contract in place. And a love contract is where we say, we have entered into this relationship consensually. We recognize that the employer has a non-harassment, non-discrimination policy, and that this relationship, should it go south, we are not going to claim that we were harassed and discriminated against or forced into this relationship. And we're also not going to let our drama, when the relationship falls apart, play out in the workplace. And we're also not going to canoodle in the corner and text love emojis to each other on our breaks. So,
like a B-52 song, right?
That's right. We are not going to be the love shack. Yeah, sample,
yeah.
yes.
Yeah.
Yes. All right, yes, a love contract.
That's what it's called.
Okay, so a hostile working environment can be anybody. It could be a supervisor who is permeating an offensive, unwelcome severe or pervasive conduct, sexual conduct in the workplace that a reasonable person would find intolerable. But it could be coworkers. It could be you've got, you know, the guy that thinks he is like, you know, the hottest thing ever since sliced bread, and he's like hitting on all the ladies. Or you could have a customer that thinks that he or she is quite the Casanova and they're always hitting on your people. Or it could be a vendor, a supplier. But somebody in your work environment, whether they're a third party or someone that works for you or you yourselves, you shouldn't be doing this either, is engaging in some conduct that severe could be one time is enough. So one time, like exposing yourself, rape and assault, anything.
Really, any touching.
Any.
These days.
Harmful. Yeah, touching. Not like I'm patting you on the shoulder, oh, you've had a bad day. Not like that, but egregious touching. Or pervasive, which means when you look at the course of time that these things have occurred, it's pervasive that the workplace is permeated with sexual whatever, tension and harassment because of this person or this group of people. So a supervisor could be a part of that, but it could be coworkers doing it to each other, it could be customers, it could be vendors, it could be anyone. So sexual harassment can be the unwanted sexual advances versus asking out on a date. Again, don't like a lot of dating in the workplace, but it's going to happen. If you ask them out once and they say, no, I'm not interested, then you need to stop asking them out. Because if you continue to ask them out and say, oh, you might change your mind, I really am a nice person to hang out with, at some point you're crossing the line into potentially harassing them. So being flirtatious, propositioning, asking for sexual favors, suggesting some kind of bad thing will happen to them if they don't take you up on it, gestures, displaying suggestive pictures, emails, things in the workplace. I have had that happen where someone has something up on their cell phone screen or on their computer screen, and it really shouldn't be there because it would not be in line with having a harassment, discrimination-free workplace, and somebody who they didn't intend to see it sees it. And so now we've got a problem because they saw something that they shouldn't have. Now, does that mean that you're going to be sued for millions and millions of dollars and lose because you had one inappropriate picture on the computer? Probably not. But what you do with that, once you find out about it, is going to be the issue, and we'll get to that in a minute. So talking about sex and sexuality, it's common, particularly, again, we've got a lot of young folks in our workforce. We have a lot of people who have never worked anywhere else. We have people working late nights and weekends, and a lot of times there's sort of an after culture that goes with the industry too, where people are going out at night and they're hanging out. And so they talk about their dates and their sexual experiences and all of these things while the business is slow for the day. And at some point, that can become a problem. I mentioned exposing oneself. I will tell you, probably every year to 2 years, we get a call about someone exposing themselves in the workplace. I'm sorry to say it's always a man. Not trying to pick on you. I'm fairly certain that if a woman had exposed herself in the workplace, no man has ever complained about it. But it could very well happen. But I will tell you, the only cause finding I have ever had from the EEOC was on an exposure case, and here's what happened. So we had, it was an auto dealership, and we had a cashier, a young gal in the cashier's booth. And there was a mechanic who was good 20 plus years older than her, was hitting on her, asking her out, saying some inappropriate things. She goes to some very low-level lead, not even in my mind someone who's truly a manager, but because that position was not well defined and he had the name manager in his title, it was good enough for the EEOC to call this person a manager. She went and she said, hey, I just want you to know so-and-so is hitting on me and asking me out and saying some things. I don't want to get him in trouble and I don't want to make a big deal out of it, but I just want you to know it's happening. Okay, so what little manager should have done is said, thank you very much for telling me that. I do have to tell Human Resources because now that you've complained to me, I have a duty to take it forward. I understand you don't want to get him in trouble. We're going to handle this real responsibly and as confidentially as we can, but I can't keep it quiet. Thank you for coming to me. What do you think he did? Nothing. Nothing. He does nothing about it. So fast forward 6-8 months later, and this team lead guy is even gone at this point. And now this technician exposes himself to the woman in the workplace. Well, of course, HR's on it like that. The manager's on it. They call the police. They have the guy arrested. They participate in his trial to get him convicted. They, take care of her, whatever needs to be done, and then she sues them for discrimination. And the EEOC said, yep, you screwed up, because you had this low-level manager that when he was told at the earlier point in time that we could have gotten in there, we could have investigated and remediated the conduct, and you didn't do anything about it, and that little manager who didn't even work for us anymore made us liable. So that's the scary reality that you need to take back to your supervisors. When I train supervisors, and Steve and I do this all the time, I do supervisor training a lot, and I always tell supervisors, you are the company brain. Anything that you do as a supervisor, if you break the law, if you harass somebody, you discriminate against somebody, it's as good as if the owner did it themselves, because it's strict liability. It goes straight up to the top. So
a supervisor is not an employee, and a lot of them don't realize that.
Right. They don't understand. And again, most of our supervisors, and in my background too, I worked my way up through the ranks. So I got promoted because I did a good job, right? I was very fortunate that the nonprofit I worked for, when I got into management at a very young age, they actually had me trained properly as a manager, as a supervisor, how to deal with employees. But I will tell you, most businesses don't have the time or the resources to invest that kind of money into the people that they promote from within. So how do we learn our supervisory skills? We learn our supervisory skills from the people that supervised us before, right? And sometimes we learn from those supervisors, well, these are things I don't want to do. Like, I don't want to be a jerk to my employees, but we might not realize there's some other things that we're doing as supervisors that we still shouldn't be doing. So things that we need to be aware of. Again, shouldn't be touching folks at work, but there are times when it might be appropriate. There's been a death in the family. There's a sick family member. They find out they have cancer. I had someone today that had recently had they had a pet die, and they're just completely distraught. And first day back to work, and I said, "Are you okay? Can I give you a hug?" And she's like, "Yes, I could really use a hug right now." It's not sexual harassment, but it was me being a compassionate human being. So
I'm not compassionate. I have to know you 20 years before I give you a hug. Especially the people in the workplace.
So again, you've got to use some common sense. But when these things, the touching, the hugging, the kissing, I call it the hot boxing, when you could easily get by them, but you try and brush up against them anyway. Those kinds of things, and I've had some charges where a gal said, he brushed by me when I was at the photocopier. Okay, first of all, there's this much room between you and the wall and the photocopier. I'm fairly certain he wasn't trying to brush by you. I'm like, did he grope you? Did he? No, he just brushed by me. Okay, well, that's not going to be sexual harassment, but maybe we tell him to ask you to step out of the way next time. So things like that. But when it starts to become excessive, pervasive, we might have a problem. Harassment based on any other categories, it's the same idea. The only difference is there's no quid pro quo when you're talking about race, age, disability. You're only talking about the hostile working environment standard. So again, it's severe or pervasive, unwelcome conduct that rises to the level of permeating the workforce, and a reasonable person would find it unreasonable. So other harassment could be certainly racial slurs, epithets, jokes where you're making fun of a particular race or gender. I get this question all the time, what about the N-word? My rule is no one uses it. No one uses it in the workplace. I don't care what your background is. I don't care what color you are. I don't care if you feel that you're entitled to use that word. Nobody uses that word in the workplace. Let's just make it that simple. And then we don't have to worry about someone taking it the wrong way, saying it the wrong way, someone being offended. We just don't use that word. But being vulgar, telling jokes, name-calling, being abusive, sending text messages and emails. My rule is you don't text with your subordinates. I don't like text messaging with subordinates. First of all, I can't keep track of those. I can keep track of an email. I can probably even keep track of a voicemail, but let's face it, we change our phones a lot. Our phones get broken, they get lost, they get stolen, and your text messages, other than pulling your phone records that I can see a text message occurred on a date and time to a phone number from a phone number, I can't see the substance of those text messages. And so if you are texting with subordinates, or your managers are texting with subordinates, it becomes open to interpretation about what that stuff was in the text, right? That the text may or may not be there anymore. So that
but if it is there, it's discoverable.
Of course, if it is there, it's discoverable, but you have to realize too that the life of a charge of discrimination is long. So right now the EEOC is so backed up that I have charges that have been pending between 2 and 3 years. I have one that's been sitting for 6 years. That is how long these things will sit. Well, what happens in that period of time? Evidence disappears, employees turn over, our memories fade, all these things happen. Certainly our text messages from 5 or 6 years ago are probably not going to be around. So if you do have text messages, I always say download them, print them, put them in the file if you do have them. But I think one of the easiest ways is to not be texting with your subordinates because again, it could be a problem. So we've got to be careful about mocking, using stereotypes. That's a whole nother thing. And again, a lot of times people don't realize it and they'll say, oh, well, I didn't mean it that way. Or they start the joke with, don't be offended, but have you heard? If you're going to start something with, I don't, or my favorite, I'm not a racist, but. If you have to qualify what you're about to say with, I'm not a racist, I'm not a homophobe, I'm not a sexist, if you have to...
I probably shouldn't say this.
Or I probably shouldn't say this, or then that should be the end of it. You probably shouldn't. Where's our sound?
Oh, and we got a new guy. I don't know if he knows how to do anything, so don't ask him to do anything complicated.
You're an idiot, aren't you? Come on, figure it out. You are the absolute worst.
So we get a lot of questions about bullying, and is bullying harassment? Sometimes bullying can be illegal harassment. It can be based on someone's category, and sometimes you just have an equal opportunity jerk. Now, the equal opportunity jerk is as big of a problem as the person who is actually harassing or discriminating against your employees, because they are creating negativity in the workplace and they're still creating liability. Because how do we discern where you're a jerk about this because of my race or my gender, or you're just a jerk? And I will tell you, I had 14 lawsuits about 3 years ago with the equal opportunity jerk defense. And you have to go before a jury hoping that they do not like the plaintiff more than they don't like your client, because you can't deny things were said or things were done. You just basically have to take the position that, well, but they do it to everybody. It's not because of their race or their gender, their religion, or because they were pregnant. That's just how this person was. And I always tell my clients, please, let's find who those equal opportunity jerks are now and let's work with them, because I don't want to have to defend your business saying, yeah, we were bad, but the plaintiff is worse. It's a very tough road to hoe. So bullying in the workplace can be just as bad as harassment. So conduct that can create liability, obviously if you yourself or your managers are engaging in the harassing or discriminatory behavior, that's liability. If you as the company knowingly allow it to occur, or you fail to properly investigate and respond to a complaint, the focus then shifts away from what really happened to how did you respond. And I see this a lot in the on the way out the door complaint. So you've got someone you fired, and they say, oh, well, I just want to let you know that so-and-so harassed me and asked me out on dates and grabbed my rear end in the kitchen over the last 6 months. And of course, in your mind, you're thinking, how true is this? Why would you wait till now? But you still have a duty, even if that person is on the way out the door, to get, I would stop and say, okay, I'm glad you told me. I want to get your statement. I want to find out exactly what happened. Because if they are telling the truth, it's not going to change the fact that they're fired. Like, you're still fired, honey. This is like, that's not going to change that. But what will change is if you do have an employee or a manager who has been harassing folks, we don't want that to continue just because that person is gone. So a lot of businesses will say, well, the person was on their way out the door, I don't need to do anything about it. No, you still need to do something about it because you still could have a person working there that is the harasser. And I've said this for years, don't be the story. Even well before the whole Me Too movement came along, don't be the story. Manager, standard, strict liability. If a manager, owner, supervisor, someone in a position of authority is doing the bad acts, it's straight to the top, strict liability, as good as the owner did it themselves. If it's a coworker or it's a customer or a vendor, once you know or have a reason to know, you have a duty to act. So if you observe the conduct and you think it's in violation of the policy, you now have a reason to know. If an employee comes forward and complains about a customer, a vendor, a coworker, a manager, you now know and have a reason to know, and now we have a duty to act.
The only exception to strict liability is if it's welcome, and that costs a lot of money to show something was welcome.
Right. Well, and again, that's the whole unwelcomeness of it. And so we get into the situations where, you know, they say, oh, I was offended by these comments and these jokes, and then you find out that the person was also engaging in the same kinds of conducts and jokes. Again, at the end of the very long, expensive road of litigation, we might win. But even when you win these cases, you've lost because you're never going to get your money back. The plaintiff's lawyers, they're going to get all their money back for the most part.
If they win.
If they win, because these statutes are written to be employee friendly. They are not employer friendly. Most of these statutes are written where you as the employer will never be able to recover your fees and costs. And you certainly won't get your life back in the time that you've spent litigating exhaustively these claims. So like I said, even if you win, you lose. You get the pat on the back that you defeated someone who brought a wrongful claim against your business. But quite frankly, even if you could get money, a judgment against them, could they satisfy it? Of course not, because if they had the money, they probably wouldn't have sued you to begin with. So it's kind of a vicious cycle.
It's a fee shifting structure. So when Congress put these laws in place, they did so thinking that the only way to get attorneys to represent these folks was to give them some incentive. And the incentive was if they win the case, then they get to ask the court for fees from the company. So,
right.
You know,
because these cases are generally taken on contingency by plaintiffs' lawyers. So.
Doesn't work the opposite way.
It doesn't work the opposite way for you. You have to pay your bills every month as they come, and you know, the plaintiffs don't generally have to pay anything because their lawyer is going to take their cut from whatever they either get in a settlement or a judgment toward the end of the case or at some point in the case. So properly responding to a harassment complaint is obviously, if you're going to share any of this with your managers, I've included, don't do the investigation without guidance. So if you are an HR person, you obviously probably have the guidance you need, but you might also need outside counsel. You might need to pick up the phone and call me and say, hey, I'm getting ready to do an investigation. Do you have a checklist of things I can follow or some tips that I can follow? But what we don't want to have happen is managers just running amok, trying to conduct an investigation and taking statements from people, and half the time these things that are in these statements we don't want written down in a statement because they're discoverable. So you need to get guidance before you go running off and doing an investigation, but don't wait to do it because time is of the essence. Once you know or have reason to know, you got to jump on it, because at some point, if it takes you months and months and months to get to the end of the investigation, there's going to be a lot of question about what was taking you so long, what were you doing. Don't tell them to go work it out with a harasser. That is not the way to not send them back and say it's unwelcome. Years ago, there was actually case law that said that the employee was supposed to tell the alleged harasser that it was unwelcome and to stop. at some point, someone wised up and said, quite frankly, if the person was comfortable with the conduct, then they probably wouldn't be unwelcoming to it. So we don't tell them to go back and work it out with the harasser.
Sort of the fox guard in the hen house.
Yeah,
you know,
exactly. Don't take a position on whether or not they have a claim. Don't write in an email to other managers. Your emails are all discoverable. Don't say, hey, Sally was being harassed by Mark. That email is going to show up in the lawsuit down the road where you have already said so-and-so was harassed. Now, if we are having privileged emails, that's a whole other thing. If you hire us as your counsel, there could be privileged emails, but don't tell them that they have a claim. Don't tell them they don't have a valid claim.
Don't use the terms of art. Don't say this is sexual harassment.
Yeah.
Describe the conduct, the who, what, when, where, why of what occurred, but avoid jumping to what we would refer to as a legal conclusion.
Right, yeah. Don't tell them they should go see a lawyer or they should go to a government agency. That is the last thing we want these people to do, although we can't stop them from doing that if that's their choice to do it. And I don't know how many of you here have heard this from an employee you're terminating, I'm gonna have my lawyer on this. I always laugh. Like, how do y'all have all these lawyers? Like, I don't even have a lawyer and I am a lawyer. So they always have a lawyer. But we don't want to push them into the arms of these lawyers and government agencies. Never agree to keep it quiet. We can agree to handle an investigation confidentially, but we're not going to keep it quiet. Once you know, you got a duty to act. We can't retaliate against the person. Again, we can't take a negative action. I want to get to that screen here in a second. Again, don't be talking about it with other managers, employees, customers, only people that need to know and are intimately involved. We got to keep it confidential. If you're going to handle an investigation, these are my basic steps. You're going to get their full statement, the initial complaint. You're going to interview them. You're building a timeline, the who, what, where, when, how. When did this happen? Where did this happen? Because if you have cameras, you're going to want to go back and pull that video footage if you can. I can't tell you how many times we've relied on video footage recently when we're dealing with these investigations. You got to decide, do we need to put someone on a paid leave of absence or an unpaid leave of absence? Do we need to suspend somebody? Do we need to call a lawyer? Who's going to be part of the formal investigation? How are we going to do it? Who's going to conduct the interviews? What questions are we going to ask? We got the documentation. Then we've got to come to a conclusion. What's our conclusion? Do we got to fire somebody? Do we need to demote somebody? Do we need to move somebody? Firing the harasser is not always the solution. Sometimes it is, but it's not always, because again, depending on whether it's a manager or a coworker, sometimes remediating the conduct might be something short of termination, with a final written warning that if you do X again, then you will be fired. But these are things
suspension.
Suspension.
Michelle, I'd like to make a point on documentation, if you don't mind. Yeah. A couple of best practices on documentation. If you are going to do documentation, please make sure it's legible, because as Michelle pointed out, we get these claims a year and a half, 2 years afterwards, and we can't make out some documentation sometimes. We can't read the handwriting. And if you're going to get a witness statement, I think the best practice is if you're getting a witness statement that's witness conduct, rather than you take the statement down and having that person sign it, have that witness put that statement in their own handwriting. And I've seen that be very helpful, because it's too easy for a witness 2 years down the road to just say, well, my manager put that in front of me and I just signed it. I didn't know what was on it. They can't disclaim it if it's all in their own handwriting. A couple of best practices there.
Okay. So I think we're pretty much about out of time. I already talked about retaliation. Again, you don't want to take an adverse action against somebody because they complained. Now, there might be things going on that you have to take an adverse action against somebody. It has nothing to do with the complaint. Sometimes there are things paralleling. That's where you definitely want to get with HR or your legal counsel and make sure that you're crossing the T's and dotting the I's, because we got to fire somebody while there's an ongoing complaint or investigation. We just want to be able to show that the complaint was not the catalyst for it. And even people who participate in the investigation, so witnesses, they can also bring retaliation claims too. So you want to keep those things in mind, that it's not just the person who is complained, but those who are engaged in the investigation as well.
And as with all things in life, timing is so important, particularly in retaliation cases. And
so I'll leave you with this as we go to break. Basically, you got to ask yourself, would I do this if my spouse were present, my grandma, my children? Would I say, or engage in this conduct? Would I do these things or say these things if the person was in the protected class that I was talking about was there? What if I'm being recorded? Because these phones that people have, you know, they record everything, and it's nothing to like turn your phone on and be recording. So if you were being recorded, would you want to hear that back? Would you want to have to defend your words to a jury? If any of you ever had jury duty, I have. If you've ever been on jury duty, you're what, with 12 people, all different backgrounds, all different perceptions. Some of them don't know, you know, anything about anything, but they think they do because they watch a lot of court TV. You always got to get at least one person on your jury that watches court TV and knows everything. So, but if you've been on a jury, you know that the humor of the witnesses, the background, those things do not play to a jury. And so it's very hard when you've got 12 people who don't know you and know your personality, your background, your good character, are judging something that you did or said or did not do. So if you would not want to have to answer to a jury and have 12 people judge you in what you did or did not do, then don't do it.
On recordings, one comment on recordings. Surreptitious recordings are admissible evidence in the court of law. Louisiana, if I'm not mistaken, I know Mississippi's a one-party state. I think Louisiana is too. So that means only one party to the conversation has to know that conversation is being recorded. If we were a two-party state, then both parties would know, otherwise it'd be an illegal recording. So we're faced with that quite a bit. We get a surreptitious recording, an employee recording their supervisor. You may have a policy prohibiting recording in the workplace, but that doesn't mean that recording, if it's brought forward, becomes inadmissible in a piece of litigation. So I always tell managers, when you're talking to your employees, just assume you're being recorded.
Okay, great. Well, thank you.
We're going to take a break?
I think we've probably taken most of your break. 10-minute break.